All right, thank you, everyone. Just a reminder, we do have our next panel set for October 13th. So if you have some ideas or suggestions, please email me. But let me introduce Taline. She will be our moderator, and then she will introduce the rest of the panelists. So Taline, it's all yours.
Thank you. Good morning, everybody. Taline with Chicago Title, part of the elite team. Today, we're going to talk about title, and the discussion is going to be differently with each participant. So our participants today are Daniel from First American Title, Raul from Old Republic Title, and Steve, my 26-year partner from Chicago Title, part of the elite team. We're going to do it a little differently today than any other panels we had. So each panelist is going to talk to us about a situation or a storyline that they're in. We're going to ask maybe 1 or 2 questions after each panelist, and then we're going to open it for Q&A at the end. So I'm going to start with Daniel from First American Title, and he's going to talk to us about vesting today. Go ahead, Daniel.
All right. Good morning, everyone. I have a story, and so there's I'm going to be talking about vesting, just in advance. This is a story where I haven't had a friend, husband and wife, that reached out to me. They're going to buy a home soon. And they asked, like, hey, Daniel, there's different ways to hold title. And so what are some of the ways that I can hold title with my wife? And I let them know that there are 3 types of vesting, or we call them like types of ownership, that they can hold the title in. And so the first one is joint tenancy. And so joint tenancy, and the second one is community property with right of survivorship. And the reason why both of these are most common is because both has right of survivorship. And so in the case that the husband or the wife passes away, unfortunately, their interest would go to the surviving spouse. And then third one, which is a slightly more costlier one, is putting the property in a trust. So you'd have to hire an attorney, create the trust, change the vesting over to the trust, and then the trust would lay out all the verbiage stating that who are the heirs. And so if the wife passes away or the husband passes away, does it go to their children or to their wife? And you can lay all that out with your attorney. And so those are the 3 common types, the third one being the most costly.
So title companies have flyers on how to hold title. If you're interested, please reach out to any of us, and we can email you or get you a hard copy of those flyers, just because it will be nice if you can give it to your clients. Meanwhile, before I transfer this to Raul, I would like to see if anybody has questions for Daniel in regards to vesting.
I do. This is Maria. Question, Daniel. So let's say a couple holds a JT, joint tenancy, and like you said, right of survivorship. Is there a time limit for the surviving spouse to file affidavit of death? Do the state require you to file within a certain amount of time that document?
Honestly, I actually don't know the answer to that question. I'm assuming that you have to file that pretty soon, as soon as, yeah. Sorry, I didn't have an answer to that because it wasn't prepared.
Actually, you don't have to right away. I've seen a lot of situations where when the heirs are selling the property, they do record the affidavit at the time of the sale. So you don't have to right away.
In other words, there is no time limit.
Mm-hmm.
I don't see any other questions.
Okay, so Raul is our next participant, and he's with Old Republic Title. So he's going to actually give us a storyline associated with the vesting. So go ahead, Raul.
Good morning, everybody. Thanks, Taline, Sabrina, Rick. I appreciate the opportunity. And remember, this is just a story. The names are fictional. They're not true. Just kidding. And anyway, in our business, we get calls on behalf of other transactions to evaluate whether or not that company did the right thing in making a decision. In this case, about a week and a half ago, I was asked to review this file on a single family home. And we concluded the same thing that that title company did. So there's a lot of similar conclusions in our business. This case is a single family home where the vesting is held in the trust on behalf of the trustee. The trustee dies. However, 4 days before her death, the trust is amended and replaces the original trustee with a brand new successor trustee. The amendment was executed by an ex. And as you know, when you have an ex amended on any document, it has to be witnessed by how many people? 2. You have to have 2 witnesses on that. So the notary was inconclusive and of course, not valid. So the question was, what's the next step? And obviously we concluded that we had to find out what is the capacity of the trustee originally before she amended the trust. And then based on our determination, we determined that probate would be the most logical solution. So we concluded the same situation as the other company did. Hopefully, if you have any questions, I'll be more than happy to answer them.
Raul, this
Yes.
is Carmen. Can you clarify that piece about the notary signature not being, did I understand you to say that it wasn't accepted?
It was not accepted because when you have the transfer, in this case, the trustee marked by an X, it has to be witnessed simultaneously by 2 witnesses, then notarized.
Okay, can that be challenged by the person who's now the new trustee, supposedly, or wanted to be?
In this case, yes, it will be challenged because they're going to have to go to court. They're going to fight now for quiet title because we have 2 discrepancies. We have the original successor trustee, and then based on the amendment of the trustee that the original trustor wanted, they have a second successor trustee. So yes, this is going to be litigated in court.
Thank you.
Anybody else has a question for Raul?
Thank you.
Okay, so the moral of the story, honestly, vestings are very, very hard, and it's important thing. So like Daniel said earlier, the best recommendation is to have a trust and be careful as far as the amendments and what you do. I have a situation right now that they completely changed the trust and they named so many different people than the original. So be careful, because at that point we realize, you know, why somebody is changing their trust so differently. Anyway, beside the point. So now the third, yeah.
So the other point I wanted to make is that in our industry, we have similar clients, and they may open the transaction with you and you may come up with a statement on your preliminary report that requires some additional documentation. And then the client says, well, no, I don't have that. We don't have to go that way. So they'll come to me and then I'll open up a preliminary. And in this case, we concluded the same thing. That's what happens in many cases.
Raul, this is Pam. If on that situation that you presented, if the notary had the 2 witnesses, would that have been okay?
That would have been acceptable, correct. That gives validity to the signature, the X.
Correct.
However, from our perspective, we would challenge the mental state of the party. Very unusual that you have the trustee pass away within 4 days. So we need to know what the scenario is.
Correct.
Raul, Carmen again.
Yes.
Is the notary on the hook here a little bit if it went to litigation?
Carmen, can you, I'm not quite sure if you're asking.
Meaning, should the notary have known that there are 2 witnesses required for this case
Correct. She should have. Correct. But a lot of times we know a lot of things and we just keep on going. We ignore it or we try to forget. Oh, it's okay. But no, you are correct. The notary should have known that when you have an execution by an X, you require 2 witnesses.
By the way, let me just say how valuable this session is, because there's a lot of detailed nuances that I'm not aware of. And this is really, really informative. Whoever thought about it, I really appreciate it. Thank you.
Sabrina, thank you.
Thank you, Carmen. Okay, so
I have a question. It's Vivian. I have a quick question.
Sure.
Regarding the person signing it with an X, doesn't that automatically mean that they're not in the right mental capacity, that they can actually sign a form, which is why the X was there?
Not at all. Not at all. They can have all their cognitive ability, except that they are not able to make a signature correctly, legibly. So they mark an X, but that's validated by the presence of 2 people.
Okay, sounds good. The third person is Steve. And Steve is going to talk to us about statement of information, which also we call it SI. Go ahead, Steve.
Geez, that's what I was just going to say. Thanks, Taline. Mine's more of a title tip along with a story at the end. So like Taline said, when you're getting yelled at by escrow to get the SI in, that stands for, we got a lot of acronyms in our business. That stands for Statement of Information. A lot of information on these documents, and a lot of times your clients are saying, why do I got to fill this out? Well, the biggest title tip I can give you is when you're taking the listing, fill out the SI, the Statement of Information with your clients, because we're going to want to clear it. The title company who's doing the transaction is going to want to clear it and make sure there are no judgments against your seller. A lot of times they forget. A lot of times there's a unsecured tax lien. There's a lot of things that can attach to the name run. The name run is called the general index. So you've got the prelim, that's the legal description, voluntary liens, deeds of trust, easements, all those great things that are in the prelim. But then there's the name side of things, the general index, and that's where the SI is cleared from. So a lot of times they record a judgment and there will only be a property address there. So when you put the property address in, when they put their social in, when they put their driver's license number in, one of those things might hit. Very few judgments are recorded without any of those information. But when they put all that information in the SI, we can clear it and see if it hits their names. And as we know, there's a lot of common names out there. I mean, Jones, Smith, just as a couple of examples. Taline's last name, Baghdassarian, is kind of the Smith. So if you think we don't need it, we do. And we need them from the buyer also. So once it gets into escrow, the buyer will be asked to submit an SI. A lot of times things come up on their credit report and we can get them cleared up too. So with that said, just a quick story. Taline and I were talking and we get asked a lot about someone that says, hey, I've got a judgment, but if they quick claim it to their cousin, maybe it won't show. Now that's avoiding the lien. So what will happen is that as soon as Baghdassarian comes into title and then Baghdassarian deeds it to SOMMERS, we backvest to Baghdassarian and check that name also. So if we're going to find that lien. So it's called avoiding the lien, and it's going to pop up one way or another. So there's really no way to avoid it. We're going to run all the names on the uninsured deeds in the chain of title. So they're very, very important in the transaction. Make sure you get them in on time. Make sure you get them in early so we can clear them, and we'll be a lot better off and get your transaction to the finish line. So I hope that was helpful. Any questions?
Steve,
Sorry, Taline, Ira?
Yeah, so the general index is your California filings only, but what if somebody had something in another state and it was a recourse state? Do you have any way of knowing what's going on with other states? And maybe that's because of the size of your company.
Well, it's a good question, but here's the deal on that. If the lien holder doesn't record an abstract in California, then it won't come up. We're only running our general index.
Okay, Mr. Barnes, do you want to ask your question?
Yes, when we have an SI, tend to get them very early, as soon as we can. And then I occasionally have asked the title companies to do a date down on it right away because of things that you are hearing are kind of suspect with these individuals. How come you guys seem to always wait until the last day or last few days before you do a date down? And then we come up with a tax lien and all those kind of things, and we're running around like we had no intelligence.
Yeah, Rick, that's a good question. And I will tell you that some of them, not many slip through the crack, but if you bring it to any one of my attention on my team, we're going to make sure it gets done quickly and properly. But a lot of, I will tell you, 9 times out of 10, we didn't get that SI to the last minute also. But in your case, you're talking about it came in nice and early. We have a SI clearing department. So we'll scan it into the system and it'll get cleared. And so it's one of those things where give it to us early and it'll get done.
Okay. So should you guys be making more of a point of that on your transactions then, that SI, the importance of that SI helps delay at the end of escrow?
Well, the prelim does come out with an SI in it. And I know that like the tip that I started with was when you're signing up the listing, pull an SI off of our website, get it done and get it to us right away. We'll get the prelim started and we'll clear the SI all in one shot. So we get the hyperlink prelim, all the plotted easements, SI's cleared, you are ready to go.
Another question.
One thing on that note too is that so often our prelim actually shows some of those notices in there and the agents don't pay attention until the very end. We're ready to close and say, well, what about this judgment? I said, how come you didn't tell us to the end? Well, it was in the prelim for day one. No one looked at the prelim to see that there was an IRS tax lien or judgment in there until we're ready to close. And that's one of the biggest issues we have on that. It's not even so much the SI, but them not reading through it.
Yep, good point, Anthony. You're kind of guilty until proven innocent, and the SI will clear it if it's not yours. That's another part of that.
Hey, Steve and Anthony, it's Carmen. In the prelim, if a judgment comes up, and let's say the agent didn't look at the prelim, do you guys not start getting busy to remove that judgment or clear the title?
That's not really our issue, is that we provide everything that's on title. If they look at it, we assume that everyone knows it. I mean, the seller is selling a property, they usually know that they have a judgment against their name, and that's going to be, the escrow will then order a demand, and that'll get paid through escrow. So if it's in there, we're not doing anything about it unless they're brought to our attention. Now, if you bring it to our attention, say, hey, my client said that they paid this off 5 years ago. Now we're going to start looking and searching out what happened. Do they have a copy of the council check that they paid for? Do they have a release? Did they get the release and maybe never recorded it? So these are items we'll go through, but we provide everything that's out there. Even like when you're looking at there's an old deed of trust on there and saying, Anthony, how come you didn't remove that thing? It's showing a 1995 deed of trust. Well, we don't know it's been paid off. I mean, it's still showing a record that it's been open and needs to be paid off. So unless somebody puts it to our attention, we're not looking any further for it. That's what the prelim is for, is to bring it to everyone's attention on what is still showing open on there.
That's a great point. Make sure you look at the prelim. All those items are very important. So even if it's not a Chicago title prelim, we're glad to kind of point you in the right direction. So read those prelims and we're glad to read them with you.
Yeah, just bring them to me.
I saw Jenny had a question.
Yes. Hi, everyone. I have a general question. In my 36 years, I think only had 2 situations where I had clients have to go to a title company and take some kind of legal action. And hopefully that's everyone else's situation too, where they haven't had to go through that. But I'm hearing now that there are a lot more things that come up. So what should we really be watching for? What items are there that are the most susceptible to some kind of legal action, and how do we avoid that happening? And any of you experts can chime in.
So Jenny, are you talking about a claim?
Yeah, any kind of a legal claim that comes up as a result of something that got missed in the title search, something that occurred where then the client couldn't do something with the property that they thought they could. What are the most common legal issues that come up, and how do we avoid that from happening so that we can protect our clients, ourselves, all of that?
Well, there's the biggest reason to get title insurance right there, is because we are writing a title policy based on the liability, the sale amount of that transaction. So if there is something we missed, that is a obvious claim, and we have a claim department that can start things and figure out what the damages are and what the claimant, is entitled to. So we do have claims. It's not just all taking the premiums in and moving the seller onto a new spot and insuring the buyer. There are claims, and we handle them every day.
Jenny.
One thing to make note of too is that once we know about something, we have a duty to disclose it. And so in certain situations, we have it where there's obviously an encroachment of some sort, the neighbors using a certain area about that. And you ask for us to do an inspection, we find it, we now have a duty to disclose it. If the buyer's fine with it and they're aware of it, it's not covered because they bought it knowing that there was an encroachment from the neighbor's fence on their property. So after we close escrow, neighbor says, hey, move the fence, and now they want to file a claim. That's not covered. Items known to the insured or insurer are not covered items. So if they knew about it, they can't go and file a claim after the fact. So, well, if we know about it, we're going to disclose it as an encroachment. Once we disclose it as encroachment, you're probably going to have a problem with your lender. So talk to us prior to getting in that situation. If there's something that's going to have a major impact on an encroachment, sometimes it's pretty minor. Look, would you still buy the house if the fence was moved 2 feet over? Yes. Well, then it's not going to make a difference. It's been disclosed. We don't have to worry about being a claim after the fact. If they don't know about it, it comes up. That's when we're going to go into the claims department. But always talk to us prior to getting in that. We'd help you out, whether it's our file or not, kind of give you some guidance on that.
Jenny, to answer your question, yes, encroachments are one of the claims that we get. The other part is CC&R exclusions, height restrictions that the city has imposed, and for some reason or another, our searching department forgot to disclose a specific document, and then you have a developer that was anticipating no restrictions on height, and that's one of the things that I've seen in addition. Height restrictions, encroachments, things like that. So everybody's correct. It happens.
Yeah, Keith Sorum just asked me what a date down was. And when we date down the file, Keith, if we open the title report 60 days ago, we'll date it down at the end towards closing time. So we can see if anything else is attached to that legal description so that we need to add to our prelim, and vice versa. We'll date down the general index to see if any judgments or involuntary liens have also attached to the buyer or seller at that time also. So get ready for escrow. Good question. Lots of good questions.
Thank you.
Yeah, actually, Rick, going back to what you said as far as the SI when we run it. So when we run it and then 30 days later, if we're closing it and something pops up later, just know because it was filed and recorded later. So that's why it didn't show up from the first run. So that's why we do it we do our GI run or date down at the end. So I don't see any other questions.
I got one comment real quick,
Okay.
Taline, and that's about the vesting. When you're getting your prelim, you're going to see like the Santillo Anthony Elko Trust is showing the owner saying, well, it's already been transferred to the kids. Any item that's transfer of title that's taken place, it's going to come under an item. So you'll see like Santillo Anthony Elko Trust as being the owner of it. And then it'll say subject item number 15. Item 15 is when the estate then transferred it over to the children, or there's been a change of trustee, death of trustee or whatever. Those documents will show up afterward. What we're showing is the last time there was insurance, that's the name that was insured under. Anything after that is uninsured and will show up as at the bottom where they transferred it to a husband, wife, or whatever, because it was uninsured transfer.
Okay, so I don't see any more questions in the chat. Anybody else before we end the discussion? Like Sabrina said, we have, I'm sorry?
Oh, I don't see any more. Sorry.
Oh, like Sabrina said, we have another panel scheduled on October 13th. So if there is any specific items you as agents are interested for us to, discuss it, please let us know. Please reach out to Sabrina and we'll have 3 more panelists on October 13th. Thank you.
Thanks, everybody.
Thank you, everyone. That was really great information.